Okay, I'm back. I'm so sorry. I don't know what happened actually. I've been speaking for about 10 minutes. I went back to my lecture earlier. Ang layo ko na nung nagsasalita ako and then I find out na putol pala siya, no? Uh, I don't know. Probably it's also my internet connection. Sometimes the internet is splotchy here because we have lots of tall buildings here in our area. Okay, so what I understand from the last time, I was asking you to look into the slides that I gave you ahead. So I was discussing the basic premises of the basic premise of independent contracting arrangement, no? So let me just get back to my lecture. Incidentally, marami kaninang nagsasabi, yung Funko Pop daw baka pwede ko raw ipamigay. Sa totoo lang hindi akin 'yon, no? Ipapaalam ko kung pwede ko ipamigay. No, but there are some na yung meron diyang pito, ano ba yung akin diyan? Yung Snow White and the Seven Dwarfs, 'yan. 'Yun yung akin. Pero yung marami diyan yung mga Harry Potter na ganyan, hindi yan akin. Pero kung papayag siya, pwede nating gawing recitation, no? Anyway, ngumingiwi na dito si Attorney Ends. Okay, let me just get back to the topic, no? We were talking about the basic premises. Now, take a look at your slides. So I said initially, not all who work for me, and then there's a contractual relationship, no? Okay. So third basic premise, as I was saying earlier, there has to be a trilateral working arrangement between um, me, COVID Cafe, the security agency, and the security guards. Okay? Now, remember what I told you earlier too, no? Medyo mahirap na bumalik kasi na-discarril yung aking concentration. So, I remember having told you earlier, the trilateral working arrangement has two kinds of contract, no? So the first contract is between COVID Cafe and the security agency. The second kind, which is that's a civil contract, no? It's a it's a stipulation which is born out of free will and meeting of the minds. On the other hand, the second contract is the contract between the security agency and the security guards. But the security guards are deployed back to me to actually secure my premises. So they're physically working in my cafe premises, but they're not my employee, no? So that particular arrangement is what is a job contracting arrangement, no? Assuming that this particular agency complies with all of the elements of job contracting, which we will try to memorize earlier. I was already finishing up that memorization kanina until I found out na cut na pala tayo. So anyway, I'm going back. So, third premise in your slide, it says there must be a trilateral relationship. So you have COVID Cafe, you have the security agency. Let's call the security agency Michael Jackson Security Agency. And then you have Baduy daw. Nakahalata tuloy yung age ko. Tapos, tapos, sira. Okay. And then you have um, the security guards. Okay? So that's trilateral. Now, fourth premise, the vinculum of the relationship between COVID Cafe, me as COVID Cafe, and the security agency, Michael Jackson Security Agency, is a civil contract. It is a contract for services or contract for a particular job. Okay? Now remember, in that particular contract, I am actually just giving them guidelines. It's just a parameter, no? I tell the guards, you just do the service. I don't care how you do it. I just want these results. Okay? So that's the relationship. It's a civil contract governed by the civil code. Now, the fifth premise, the vinculum or the connecting factor, on the other hand, of the relationship between the security agency and the security guards that the security agency hires, who eventually will be deployed to COVID Cafe. That is an employer-employee relationship. And that being an employer-employee relationship, that is only between the agency as the employer of the security guards. Okay? That is a labor contract. Therefore, that is governed by the labor code. Okay? Claro? Now, sixth premise. Again, I should not have any control. Why? Because I recognize that it is not I, but the security agency which has expertise over the service that I want them to do. They're experts in that particular field. Not me. Restaurant services ako eh. So, security of the premises is not my cup of tea. It's not my field. So, I now relinquish the control over the manner and method by which the work is to be done, and I give it to the expert, which is the security agency. Okay? So, that's why the law says the contractor, okay, the contractor will handle the manner and the method by which the work is to be done. He has no control. The principal has no control over the contractor except as to the results. Okay? Now, so again, that is an independent contracting arrangement. Now, remember, in an independent contracting arrangement, how do you know if that contractor, the security agency, is really an independent contractor? Then he must comply with the provisions of the Labor Code and Department Order number 174, which actually is a repetition of Department Order 18 and 18A in terms of the elements of valid job contracting, or what we call independent contracting arrangement. Now, I give a mnemonic to my students, and the mnemonic is I arm ARM, I arm ARM, I arm pati ako nawala. I arm free capital, Temwork RNB. Okay. Now, I arm free. So there are three elements to this. I, ARM, and free. I arm free stands for why it is considered independent. Okay, these are elements which show the independence of the contractor. So he has his own independent business. Kaya nga independent agad. So he has his own independent business. A, he works for his own account. R, under his own responsibility. M, using his own means and methods. Using his own means and methods. Free. He is free from the control of the principal, COVID Cafe, except as to the results. So he's free from the control of COVID Cafe because I'm results-oriented. Okay? So that's the first element, I am free. Now, the second element talks about capitalization requirement. So, it says here that the independent contractor has sufficient capital in the form of TEM work, TEM work. T stands for tools, E equipment, M, machineries, work premises. Okay? And then the third element talks about the liability of the principal with respect to the employees of the contractor. It says there that in the contract between the principal and the contractor, in that job contract between COVID Cafe and the security agency, there must be a provision there that recognizes RNB, the rights and the benefits of the employees of the security agency. So which means the security guards. So in the contract between me and Michael Jackson's security agency, there must be a provision there that says, I, COVID Cafe, recognize the rights and benefits of the security guards. Now, why is that so? Because the labor code makes the principal liable solidarily with the independent contractor if the independent contractor fails to pay his security guards. Okay? That is found in the labor code. That is the peculiarity of our labor code. Because it is, if it were really simply a civil contract, there should not be any, I will not have any obligation to the employees of that contractor sana. But because of the peculiarity of the labor code and under the principle of social justice and equity, then they said, because these people, the security guards' services, indubitably redound to the benefit of COVID Cafe. If the security guards are not paid by the security agency, kawawa naman sila. So pay muna. You, COVID Cafe, pay them first. Because their services ultimately redounded to my benefit as COVID Cafe. Diba? Kawawa naman. So, what will happen? Then, I pay because I'm solidarily liable. Then I can, however, request for reimbursement. Okay? Now, so that is the mnemonic for independent contracting. I arm free, capital teamwork, R and B. Okay? Try to memorize that. Because at least when you take your exams and or you have your bar examinations, or even for those people that are not students of law, but they are engaged in business, they have their own contractors, at least they have an idea what this really means. No? So I arm free capital, teamwork, R and B. Now, so if we now know what is an independent contracting arrangement that is valid and therefore allowed under the law, ano na yun tong, what is this NDOC thing? Okay? NDOC simply means that this is in reference to labor-only contracting arrangements, which is actually prohibited by law as a matter of policy. Because in this instance, the control actually is vested on not the contractor but rather on the COVID Cafe as the principal. So there are two ways of actually proving labor-only contracting. I give this mnemonic and memory aid to my students. Now, first way, one way by which you can prove labor-only contracting is just to prove that Michael Jackson Security Agency has no capitalization. So it has no tools, equipment, machineries, or work premises. And then, secondly, so there are two elements, no capital plus directly related. So no cap plus direct. Second element, the people that are being deployed by this contractor are doing services or jobs which are directly related to my main business. Okay? So, yung trabaho na ginagawa nitong mga empleyado ng contractor are doing jobs which are actually regular jobs. Now, if you put them both together, these two elements, wala nang capitalization yung Michael Jackson. Tapos yung trabaho na ginagawa ng mga empleyado niya, are doing regular jobs, then that is considered labor-only contracting. And therefore, that is prohibited under the law. Okay? Because they're just making use of this contractor when in truth and in fact, it's actually the the principal that that dictates to them the manner by which they do the work. Okay. The second way by which you can prove this is what is called no control. So ito na yung sinabi ko kanina. The principal actually controls the manner and the method by which they do the work. Di ba kanina ang requirement for independent contracting, COVID Cafe does not dictate the manner and method by which they do the work. Okay, kahit may capital yung security agency, if COVID Cafe dictates the manner and method by which the work is to be done, then that's an employer-employee relationship. And therefore, this is considered labor-only contracting. Now, what is the effect? The effect of a labor-only contracting is that COVID Cafe now is treated as if it were the real employer for all intents and purposes under the labor code. So COVID Cafe now becomes liable for everything under the labor code. No? So not only will it be liable for the wages, for the 13th month pay, all the monetary claims, it will also be held liable for all benefits that are not even found in the labor code. SSS, PhilHealth, Pag-ibig, yung nandun sa paternity leave, maternity leave, etc., etc. Everything. Now, even the right to self-organization, those people will now be considered as my direct employees, in which case they can now help and join in that particular union. That is the effect of labor-only contracting. Okay? You now consider the contractor, because it is a labor-only contractor, that is simply not allowed under the law. Therefore, the contractor is simply considered merely an agent of COVID Cafe. And COVID Cafe is now considered as the direct employer. It is as if COVID Cafe directly hired them from the very beginning. So, how do you determine yung time of deployment? When they were deployed, yun yung liability niya. Okay? So, again, no cap plus direct. First way, no capitalization, and the work being done by the contractor's employees are directly related to my main business. Or the second way is just to prove that the contractor does not control his employees. There's no control. In which case, what is presumed? If the contractor does not control his employees, ay sino pala yung may control? Ako. Bakit? Because they work in my premises eh. So, the contractor does not control his employees, but they work in my premises. How do they work? Then it is presumed I'm dictating to them how they work because they're inside my company premises. Okay, claro? So that's labor-only contracting. Okay? Now let's go into, well, I already discussed management prerogatives earlier. But as I said, management prerogatives is just the discretionary power of management to determine how to operate its business. So, my decision of contracting out is actually an exercise of management prerogatives. Now, how do you know if my exercise of my prerogatives is valid? Does it mean that because I have management prerogatives, ang laki eh. Diba sinabi natin, the way to operate my business is my management prerogative. So I can honestly say from hiring all the way to firing and everything in between is my prerogative. Question, is that absolute? Can I now do anything that I want? Of course not. No. Why? Because there are limitations to the exercise of management prerogatives. And what are the limitations? This is what I want you to memorize now. There are 3 elements for a valid exercise of management prerogatives. Now, management prerogatives, as I said, is the free will of management to conduct its own affairs in respect to the operations of the business. And that cannot be denied, but it has certain limitations. Provided that management, burden of proof being upon management, provided that management can prove that in the exercise of its prerogatives, it did so in good faith. Number one, it's done in good faith. Number two, for the furtherance of the valid interest of management. And number three, not purposely to circumvent the rights of my employees. Then, in all probability, the Supreme Court will uphold that exercise of management prerogatives. But absent any one of these elements, patay ka. That's already an invalid exercise of management prerogatives, and the Supreme Court will reverse your decision. Okay? So again, memorize 3 elements for valid exercise of management prerogatives. Number 1, it is done in good faith. Number 2, it is for the it is for the furtherance of the valid interest of management. And number 3, it is not to circumvent the rights of the employees. Now, these are all Supreme Court cases, primary of which is the San Miguel brewery cases, no? Ang dami-daming kaso niyan. It's like hundreds of Supreme Court cases defining what management prerogative is and what are the limitations. Okay? Okay, so now, it's already what time? 4 o'clock?
4.
Okay, are you still willing to engage? Or would you want me to already stop? Kasi meron pa sana tayong classification of employment. I want to know if you want to continue, no? Okay. I want to find out also from PALS if I'm allowed to continue beyond 4 o'clock. Or would you want me to answer muna some of your questions before I go on?
Sabi nila, yes, extend please.
Okay. So would you want me to ask some of your questions? Okay, some of the questions here. Okay. Okay. One question. If the employee has been with the company for 3 years and there is no contract and the fourfold test is satisfied, should the employee be considered regularized if the nature of employment is not clear and not documented? Yes, definitely. As I said, a contract is not an element for the existence of an employer-employee relationship. What is important is control. So, there are a lot of Supreme Court decisions in a number of your Justice Marvick Leonen decision, Fuji, what is that case recently? It's about the poultry company, no? Natividad Poultry Company. Sinabi niya doon, no? The fact that the employee has been continuously hired doing a particular job or services, it is indicative of the necessity, if not the necessity of the job in respect of the business. So which means therefore, the company can say, that is not necessary or desirable. I am let's say for example, ito na lang. Let's clarify, no? Number 1, as I said, a written contract is not necessary. Okay. You have COVID cafe, right? Tayo yan. Lahat kayo empleyado. So, usually ang alam nating regular jobs diyan, yung waiter, yung bartender, yung coffee, ano yung pangalan dun sa gumagawa ng kape? Okay? Question. If I decide that I will get a bodyguard that looks like Piolo Pascual. Question, can I make him regular? Question, is his job necessary or desirable in the usual trade or business of the company? No, it is not. Correct? It is not. Because it has nothing to do with the main business of the company. However, the law says desirability. Whose desires will be followed here? If I desire to make that bodyguard that looks like Piolo Pascual as a regular employee, will the Supreme Court say, no, you can't do that? Of course not. So therefore, that is a valid exercise of management prerogatives. Okay? Now, question. Matagal na siya. Etong security, yung halimbawa, kumuha nga ako ng barista. Wala siyang kontrata. Number one, is his job necessary or desirable in the usual trade of business? Yes. So, basta lumampas na yan ng 6 months, assuming na naging regular probationary contract yan, automatically, he becomes regular upon the lapse of the probationary contract. Question, what if there was no contract whatsoever? From the very beginning, wala. The law will presume that this is a regular job. For as long, this will be presumed as a regular job if, number one, tumagal yan ng work, okay? Kasi pwede mong sabihin, casual yan, but then again, has worked, whether continuously or broken, for about 1 year, then he's considered regular, okay? For as long as the activity for which he was hired continues to exist. In fact, as I said, the justice said, the fact that you have repeatedly or continuously hired a particular person for a particular job is indicative of the need of that particular services, in which case he is considered regular. Okay?
Ito boss, continuation.
Okay. Now, if you say po, Dean, that once there's already control, there's already an employer-employee relationship, how will the employee secure his job without a contract? Okay? Make sure that the employee, as long as the employee can provide proof that he has been paid, okay, his salaries or compensation, he has other proof, that he has been receiving certain benefits from the company, he has an ID, he follows certain rules, he gets affidavits from his co-employees that he has been working for a number of months, number of years, blah blah blah. That was already indicative of an existence of an employer-employee relationship. In which case, so kailangan lang naman kasi what we just need is substantial evidence that will be sufficient, that will already suffice as an indicative of an existence of an employer-employee relationship. So burden of proof now shifts to the employer to show that this is not an employment, but rather a job contracting arrangement. So burden of proof ngayon, nandun sa employer. Paano ipapakita? Hindi ko yan empleyado. O independent contractor yan. So he has to comply now with I-ARM Free Capital Tem Work RNP. Okay? Now, third question. In answering the bar, would it suffice to establish control to determine employer-employee relationship? Minsan po kasi hindi makita yung tatlong other elements. Okay, good. That's a good question. Now, tingnan nyo ngayon sa panahon natin. Everything is so specialized. So it is possible, lalo na yung mga nasa call center, Just imagine a call center. In a call center, it's possible that when you apply to become a call center agent, you don't actually go to that particular call center immediately. You are referred to an agency, yung headhunter. So that headhunter actually hires you. And then you're referred back to the call center. Okay? Now, it is also possible that, so you know the 4 elements, diba? Again, what are the 4 elements? Southwest Disaster Control. Sabi ko, SWDC, Southwest Disaster Control. Selection and hiring, payment of wages, dismissal, and then the control test. Okay, so ito na. So ito ngayon, meron kang headhunter agency, doon ka nag-apply. Hire sa'yo, binigyan ka ng kontrata, tapos ibabato ka ngayon doon sa call center. Pangalawa, you are being paid not directly by the call center but rather by another agency, halimbawa yung bank, diretso from the bank pays you to the ATM. The dismissal, okay, somebody dismisses you, and then you have the power of control. So in some instances, you really don't know who your employer is, di ba? Kasi ang dami-daming establishments. Ang dami-daming parts.